Good evening, everyone. Firstly, thank you all for finding time and joining us for the session. My name is Raisha Gaur, and I will be moderating this session. The topic of today's session is Universal Declaration of Human Rights, 1948, and Conventions of Political and Civil Rights. Before starting with the session, I would like to make some points. The Q&A session will be in last 30 minutes after the address of the speaker, and only the most relevant questions will be addressed by the speaker. So today we are delighted and honored to have with us our speaker for the session, Dr. Raka Arya. Dr. Arya is currently the chairperson of Center for Gender and Health Laws, NLIU Bhopal. Ma'am has also worked as member of Family Dispute Resolution Cell of DLSA Bhopal for 3 years. She is also the member of American Political Science Association, Washington, D.C., USA. Welcome, ma'am, and over to you.
Thank you, Vatan. And a very good evening to all of you. So, should I start right away?
Yes, ma'am.
Okay. So, as you all know, that we have gathered today to understand few things about Universal Declaration of Human Rights. The name you all would have perhaps heard that what it is, because we know that these days we hear a lot about human rights. But the thing is that how it has originated. This is a very important point for us to understand the relevancy and context of the certain things that we are trying to understand as human rights. We know that history goes back into 1948, as Raisha has said, that 1948, 10th December, the General Assembly adopted this Universal Declaration of Human Rights. But then 1948, why 1948 it was? Because we know that it was the time when world was witnessing a very gruesome and I think all annihilating sort of Second World War, and in which the countries were involved in a very, very violent war where they were killing each other. Mindlessly, they were killing each other. And this particular situation actually was very unprecedented for human beings to witness. Now, again, another thing that people did realize that this war, why it has become so disastrous and devastating was the technological advancement, and that has actually further, we can say, worsened the situation as far as the killing of human beings by one of another was concerned. So that's why we were just, looking at that. Was it happening for the first time? No, it wasn't. If we try to see as far as the history of war, we see that the human civilization is full of wars, history of war. They have killed each other even prior to this particular Second World War. But we know that 20th century actually has witnessed a very different scenario. First, we have witnessed that in the early 20th century, there was a war that was also very, very devastating. Then again, in a very few years' time, after that particular war ended, in a kind of disaster, another war happened. And this was even more disastrous than the previous one. Now, we know that at this point of time, a particular happening, or we can say a particular power was coming into force, and that was the United States of America, which was having a very new kind of perception and thought process to resolve certain situations. If you any of you have followed that particular kind of history, you might have seen that when First World War ended, that Treaty of Versailles, after that League of Nations was established. But they could not make much of the headway because of the absence of the very power that actually tried to create it. It means that this power was actually controlling that particular kind of situation where they can find a solution which was non-violent, meaning resolve their dispute without resorting to war. Now, but this could not happen because of their internal political system that they have. They could not join the League of Nations. But then they became part of United Nations that they established in 1945. And then they decided to, bring this particular kind of violence to resolve their disputes to an end. But then again, another, not only this, that they were trying to look for a forum where they can stop violence in future, but they wanted to actually resolve the situation that human beings do deal with each other in this particular kind of manner. So what they wanted to do was that they decided to create a particular, we can say, document or some kind of minimal standard where we all have to interact, because again it was a new situation. That number of states were coming together on a single common platform. But still, the scenario was not very conducive, because what was happening, 1948, if you all remember, was a year of colonialism also. Many countries in the world were not free. It means it was an year, or rather we can say it was a period of slavery also. America was one state that experimented in the past as far as the slavery was concerned, though they also experienced, the outbreak of very massive war, civil war in USA, but still they were not deterred by the fact they went ahead with the experiment. So they wanted to repeat it at the international level also. Prior to this, they were following the policy of isolation, so they could not become partner in that particular kind of endeavors which are happening. But when they joined us, they created new forums, new thought process. We know that they were also having their own problems. It wasn't that they were free from problems, but still, they were trying to bring some new solution, some new thought process, a fresh thinking they were bringing. So that's why they created this United Nations, which was supposed to be a kind of platform, common platform for all the states to address their grievances, and of course to negotiate with each other the kind of issues which were creating conflicts between or among them. So this availability of forum has brought many countries together, and when they came together, they decided to resolve this particular kind of situation by going to a particular mechanism or instrument that was called as Universal Declaration of Human Rights. They wanted to end this particular situation by creating, or rather grabbing the opportunity to create a kind of universal humane ethos all around the world. And that's why they decided to go for it. We know that, of course, 1948 has witnessed Nuremberg trial also and Tokyo trials also. But we know that what Justice Vinod Radha Vinod Pal has said, he said that it was a kind of conqueror's trial of the conquered. So this was not a kind of fair one. So now they have started in the context or in the terms of, we can say, justice, fairness, reasonableness, and what can be a humane treatment given by one to another. And that's how this whole process is started. And when we know that when they started thinking in terms of the UDHR, 1948, it was passed. And here, Eleanor Roosevelt, who was widow of President Roosevelt, she was the one who was heading the committee, as I have mentioned in my presentation, as you would have seen it. So what has happened in that, when she was the one, of course, it was a very peculiar situation. If you remember, 1948 means that even women, they were not very much in the forefront of realization of human rights. But somehow we have found this particular peculiar happening, that she was the one who was leading this particular drafting committee. And she was the one who actually made it like this. There is a one, interesting thing to quote here, that there was one lady who was a kind of member of, these endeavors, was Hansa Mehta. She was the one who said that you actually, choose the word human instead of man. Because generally what was happening in all the kind of such kind of documents, they were using the term man. So she said that instead of going for man, let's go for human. So that's how this word human actually came into this Universal Declaration of Human Rights. So we know about this. So these are certain things that we wanted to know about the background and how did it come into the picture. And it was an important thing because it came at a time of period when world was having weapons of mass destruction in its control. They have seen and they have witnessed the devastation it can cause. So they wanted to have a peace in the world. Now they are trying to, bring that peace by developing an understanding amongst the people of the states and the states themselves. So both were taken as party. So when we try to understand UDHR, we will find that there will be the kind of rights that will be present, will be having state and individual both as a subject. So let's see what is there. They say that as far as Universal Declaration of Human Rights was concerned, it was not legally binding. And it was just a kind of, common standards it was laying for the states to interact in their affairs without resorting to any kind of violence. So we can see that UDHR, because as we know, if we are familiar with the international law, that states are sovereign, and they are not bound by as far as these kind of treaties are concerned. Yes, international behavior says that they must be bound, they have an international obligation, but we know that there is no enforcing mechanism available. So of course, state, if they wish, they can choose not to follow it. Of course, they can of course plead any reason like national interest, etc. So they can talk in terms of that. So they say that initially this UDHR was considered just as a kind of declaration of some kind of standards which these states were supposed to follow. But we can say that this is the document that has laid down the foundation of the human rights in the world, in the modern world. They are saying that it was the first document that provided for basic civil, political, social, economic, and cultural rights that all human beings should enjoy. So they are bringing, because we know the term is saying universal, and we know that universal means without boundary. Wherever the people are existing, they all are bearers of human right. We know fundamental definition of human right also. Those who are human will be, of course, entitled for the human rights. So that I'm not focusing upon, but then I'm just explaining that in the light of that how they are saying that universalism is something which is very much part of a very different kind of system, which is belonging to the nature law system. So we are going to see that they say that, of course, there was a commission that prepared it. That was a commission on human rights, 1947 and 1948, that prepared it. And then, of course, I discussed with you, and you can see that there have been a mixture of, kind of experts who were brought to create this particular document. If you see the names, you will see they have generally tried to, have experts from different countries which were independent at that period of time. Then again, we see that how this particular thing came. Already I discussed with you the notion of human rights post Second World War and the emergence of the US as the world power. Of course, it has changed a lot, because USA was one country, if you have followed the history of that, has actually given a lot of things to the world as far as the modern democratic world is concerned. They have given us democracy, they have given us, or rather we can say they have given us instruments to check power. Of course, a country can have a fair share of its own problems, so that I'm not going to focus upon. But then, yes, I would look at the positive side that they have contributed significantly as far as the creation of such kind of structure was concerned. Then again, we know that, of course, there were countries who, because of the emergence of such kind of declaration, I think it became quite convenient for them to get their freedom. And of course, we know that 1948 afterwards, many countries in the world gained their freedom. And of course, now we are having some 190 plus countries in the United Nations as member, perhaps 200 if I'm not wrong. So they are having so many countries as members now. Now they are saying that this particular idea is divided into two. Again, we will see that it will be complementary and interdependent. UDHR, though it is international instrument, but of course it is very, very important for the domestic and national politics of a nation. Here I am going to take example of India to an extent, because India has Constitution of India and has Protection of Human Rights 1993. This act, we know that came quite late into existence. Initially, we have Part 3, of course, in the Constitution, which actually is, we can say, having all those rights which has been mentioned in the Universal Declaration of Human Rights. Now we will go to this particular nature of what this UDHR was trying to bring us as a new phenomena. It was a kind of right, because first of all, the world, as I told you, was suffering, or rather was languishing under colonialism. So right world was very, very kind of musical to their ear and of ears, and of course this human right was, I think, even more melodious, because it was based on a kind of universalism. They say that there are four understanding as far as nature is concerned. They are natural, meaning they have been created by nature. The human beings are bearer of those rights of being human. Then again, moral, of course, they can be only understood by exercising some kind of reason or rationality. So a natural phenomena has been understood by exercising reason. Then they say, since nature does not discriminate, it applies to all, it gives to all without any discrimination in a universal manner. So it applies to all without any boundary. So it's a boundaryless. The person wherever it is very much, bearer of human rights, unlike other rights. Unalienable means that, of course, when they are part of this natural rights are generally understood in the context of unalienable. As we know that rights have been divided even in the natural domain into two categories. One, we say that one cannot be suspended even during the time of emergency. Then there are other categories of rights that can be suspended during the time of emergency. So we know that this particular thing, that when they talk in terms of this unalienable, they are referring to those rights which cannot be suspended, or rather that cannot be taken away without any justification, and justification that is given by law. They may speak the terms like due process of law or procedure established by law. So we can understand that when they are speaking in terms of such kind of rights, these four criteria are very important and inherent in human rights. All human rights might be having all these four ideas that I have discussed just with you. Now, what we are saying, that what will be? Of course, we know one thing about the right, discourse in the country, that these rights, which are not legal rights, they are not enforceable rights, enforceable in the court of law. So we are saying that for a right to become enforceable, it means that if it is to be protected. Now we are introducing a language where we are saying that the rights which can be protected by states will be falling in the category of legal rights. Now here we know that when a state makes a commitment to protect a particular right, will be very much finding a kind of remedy given by the court of law if there is a violation. So legal status of human rights, we know Part 3 of Indian Constitution included them, and of course converted them into civil rights. Civil and constitution, legal right, they were converted. So we know that then we got the protection from the state. Now enforceable when become part of constitution or legal right in a state. So now we see Part 3 of the Indian Constitution, and now there is a separate act also, that is the Human Rights Protection Act 1993, which is separately making the human rights as a legal right as well. Now, one again, we see that what are the 5 important tenets that will be present even in these human rights: universal, inalienable, interrelated, indivisible, non-discriminatory. So whenever a person or human being is concerned, will be enjoying these particular rights, and all 5 tenets of this particular right they might be. When they say universal, as I told you, belongs to all equally, irrespective of their status. Now we are saying status, that will be of course an important part, without going into the grounds of prohibition, that it will be based on color of skin, or will be based on religion, place of birth, language, culture. So people will not be discriminated, or they will be, or rather here I will not say that all without, all will be the bearer of it without any, particular identification of their identity. All people are born free and equal in dignity and rights. Inalienable, as I told you, interrelated, interdependent. All rights are connected with each other. When we talk about, even if we talk in terms of liberty, equality, justice, fairness, every single thing is interwoven with one another. We cannot separate them. Indivisible, they are saying that no one right is important than another. So we know liberty is as important as equality. Equality is as important as liberty. So we know that this is also important, complementary. Non-discriminatory, as I just told you, that they will not be, they are using a particular language. They are saying that there will not be any distinction, exclusion, restriction, or exclusion on the basis of this particular, idea of race, religion, sex, region, color, age, nationality, or ethnic origin and language of a person. So we know that everyone will be treated as a person of equal moral worth. Now we start with this human rights which are being mentioned in UDHR, that is the Universal Declaration of Human Rights. They have divided it into 5 categories. Preamble, general articles, which will be 1 or 2. Civil and political rights, that will be starting from Article 3 to 21. And then again, economic, social and cultural rights, that will be falling in the category of Article 22, 27. Then others which are not falling in the scheme of this thing is from 28 to 30. Then again, now we are going to understand the preamble. If you look at the language, you can just see that the kind of terms they are using. They are saying the term inherent dignity, which is of course very important because we know it is an important component of human right. Then we will say that of course, if I say the first few lines I would like to read, whereas recognition of the inherent dignity and of the equal and inalienable right of all members of human family is the foundation of freedom, justice, and peace in the world. So it is very, very important, to keep all these components into mind, that what these human rights are consisted of. They are the one, of course, having all these components and ingredients. Second para that I have taken from the preamble is, they are saying whereas the people of the UN have in the, when they say UN, meaning all the people which are part of those states which are member of United Nations, have in the charter reaffirmed their faith in fundamental human rights, in the dignity and worth of the person, and equal rights of man and women, and have determined to promote social progress and better standards of life in larger freedom. So this is something that they have actually introduced into the scheme of things, that how the relations will be, or how the laws will be made by the states to deal with the people in their own states. Now they are saying that as far as the General Assembly is concerned, it has proclaimed this Universal Declaration of Human Rights as a common standard of achievement for all people and all nations, to the end that every individual and every organ of the society keeping this declaration constantly in mind. Then again, now when we move to the Constitution, because now I'm taking you to the Indian Constitution, because as you can understand already in the beginning I mentioned that UDHR, and again I reiterated here, that they are saying that it is a foundation of standards. It's laying down. So it's not actually creating a kind of scheme which could be legally binding on the state. Now what a state needs to do, as we know in the international law, when they become party to a particular kind of declaration or understanding or agreement, they have to actually make changes in their laws, or they have to incorporate them in their laws or in their constitution, or they have created two national laws for the implementation of those things. Here in this presentation, I have shared the combination of those things with you, okay? And I have also shared with you, when you look at, this particular scheme. I don't know whether all of you have got this particular presentation. Hello?
Ma'am, we have shared the presentation to all of the participants in their Google group.
Oh, okay. Okay, so when I just go to this particular scheme, you can see that I have given you this, because Vishnu Bharti case, the issue was observed, that meaning the judges were surprised there could be something which will be not, inalienable and all that. So they were expressing this particular thing when they had a look at the UDHR. Now when I shared this particular scheme and combination with you, I have given you that. So when you look at the UDHR Article 3, now I'll tell you that what it's talking about. So immediately you can understand. The Article 3 of UDHR says everyone has the right to life, liberty, and the security of person. So you can immediately remember what the Article 21 is all about. You know that this is speaking in terms of right to life and liberty. So you can understand that this scheme is complementary. So UDHR has been made part of the Indian, we can say, Constitution and the fundamental rights. Now again, when they speak in terms of UDHR Article 4, again when they say no one shall be held in slavery or servitude. Slavery and the slave trade shall be prohibited in all their forms. So you can see I have given you in combination the Article 23 of Constitution of India. Okay. So here we can see I just gave you this because we know that we will be having paucity of time, so we cannot discuss every single thing in detail. So I have given you all these schemes here, so you can match those things with the help of those documents that I have shared with you. So you see that whatever language they have actually used in the UDHR, they have replicated in the Indian Constitution. Now this Article 21 that I have shared with you, and I have given you certain cases also, but this is not the exhaustive thing. This is very limited one. You may find a number of more cases also as far as this Article 21 is concerned, because it's an expanding article, because it is related to the life part. So it's always expanding into different areas. Here I have given you a kind of issues that they have taken from the UDHR, and that is right to go abroad. They have included into it right to privacy. You have just seen a particular judgment came recently. Right against solitary confinement. Again, right against power fetters. That is again almost complementary with this idea of solitary confinement. Again, I gave you this right to legal aid, which is once again part of right to life. Then again, right to speedy trial, right against handcuffing, right against delayed execution. This is, that this also have been recently in debate, this right against delayed execution when Nirbhaya's case was decided. So you can understand that all these issues were raised recently also. So there is a background and there is a foundation of it. Then again, we know all the time, many a time we do hear about right against custodial violence, right against public hanging, right to healthcare or doctor's assistance, and then right to shelter. All these issues are very much part because once again we are going to see that this UDHR will also be divided into two categories, where it will be speaking in terms of civil political rights and where it will be speaking in terms of economic, social and cultural rights. Economic, social and cultural rights, you might be aware, have been made part of Part 4 of Indian Constitution. But first I am continuing once again with the Article 21. Here they are saying that what has been added further into the understanding of Article 21, it is having right to know, right to compensation, right to release and rehabilitate wanted labor, right against cruel and unusual punishment, right of inmates of protective homes that we know have been a kind of very important instrument these days to have these rehabilitation schemes implemented, because we know that the reformative measure is being adopted for the purpose. So we know that and why a reformative measure is being taken more into consideration than deterrence and retributive, because life has been considered, have been given a kind of humane treatment. Now we have seen that another area in which it is expanding is regarding drugs, environment, hazardous chemicals, insane persons, passports, atomic energy, radiation, forest. So all these areas are also getting included in it. Part 4, as I told you, that the whole scheme is inclusive of both kind of rights, that is civil political rights, as well as they are talking in terms of social, economic and cultural rights. So here once again we can see that Article 23, one they are having as the equivalent to the right Article 41 of the Indian Constitution. So I'm going to share with you the Article 23. What does it say? They say that everyone has the right to work, to free choice of employment, to just and favorable condition of work, and to protection against unemployment. Clause 2 says everyone without any discrimination has to equal pay for equal work. So you might have heard about all this, that we are talking about. So this is, when we go for this UDHR, we can understand that how it has really helped the various countries to formulate this particular kind of part of human rights that will be supported by the Constitution, which we know by other name like law of the country, supreme law of the land. And they have been given a kind of legal umbrella and legal protection by the countries. So in other way, they have been made legally binding on this particular UDHR, but itself it has contributed very significantly, because people do actually talk in terms that they say the direct outcome of this was Iccpr and of course this Iccpr. So they are saying that of course it is by other way is legally binding, but directly when we look at UDHR, it is not binding. But yes, we can say it has shown us light. It has been we can say it has proven to be the beacon of light that has actually shown us the direction. Okay, so these are few things that I wanted to share with you as far as the Universal Declaration of Human Rights is concerned. So I thank you all, of course, and I have said that it's a humble effort on my part, and I would like to thank you for giving you your patience here. So should I start right away with the second presentation? Adarsh?
Please, ma'am, please.
Okay, so let's go to the second presentation, which is, as I told you, is of course, we are knowing about it, is the Iccpr. This we know as has been the direct outcome of UDHR, and we know that when we are talking in terms of this, what it is bringing for us. Let's see. We know that we are more familiar with Iccpr than, of course, UDHR. It is something, the scheme of Iccpr is like this. I'm going to once again share with you. They say that as far as these two conventions were concerned, or rather covenant, they are using the word. Again, we know in international law, the meaning is the same almost when it's a kind of agreement where we know that states on their own voluntary terms are entering into such kind of agreements. Now here they are having two direct outcome of UDHR. One was International Covenant on Civil and Political Rights, which has been passed in 1966. There were some 170, now there are 173 states. Initially 116 states were the one who actually passed it and adopted. Now, second was International Covenant on Economic, Social, and Cultural Right. That was also 1966. So you can see the difference of time. This 1948 to 1966, and finally it came into force in 1976. Meaning it took a long period of time. That to actually come into the existence. But I really admire my country that we have actually created a kind of constitution which was already having all these things in its constitution in 1950 itself. So we will see what they are, what is the scheme. Another thing that they have created was optional protocol to Iccpr 1966, that was based on a single scheme, and that was individuals communication system, meaning how it can be communicated when there are violations by the state, meaning both the actors will be questioned. So we are going to see the states will also be questioned, and individual can also bring grievances in front of the international forums if certain steps have been fulfilled. Now they are saying both the covenants are complementary and interrelated. Already I told you that how they have divided UDHR. Rather, we can say that UDHR has been split into two. Now they are saying that together these three are called as International Bill of Human Rights. So this is the whole scheme. Now they are saying that what all have been included in this International Bill of Human Rights. Right to life, you all have heard. Equality, security of person, freedom from slavery, freedom from arbitrary arrest and detention, freedom of movement and residence, due process of law, freedom of opinion and expression, freedom of association and assembly, right to safe and healthy working conditions. Again, and then these are the combination of both the covenants that I'm giving you. Right to form trade unions and to strike, right to food, clothing and housing, right to education, and right to health. So these covenants are speaking in terms of this. Now they are saying that, of course, either way it can be actually made part of the national law. It can be the state can be directly party to the treaty, or if it is not, then of course when it has been started practicing by the number of states in the world, then of course it becomes part of the customary rules. So we can understand that there are 2-3 things that I'm going to once again share with you, and that is some 3 ideas it is introducing. It's saying duty to respect, because it's saying that 3 obligations will be there on the state. Now we are going to see that what they will be: duty to respect, duty to protect, and duty to fulfill. So what do they mean by all these things that they are talking about? Duty to respect, you might have heard when you hear a thing about part 3 of the Indian Constitution. They say, or rather they caution the legislature that they cannot create or they cannot enact any law that will be detrimental to the fundamental rights of the Indian citizen. So they are saying that state should not do anything that will be actually hampering or jeopardizing the enjoyment of the right. So they are not supposed to do anything that will be detrimental for the enjoyment of the rights. Second, they say duty to protect, meaning if they are, of course, it is the primary duty of the state to ensure that all the rights of individuals are protected. There are no violations. First, they are not violating themselves. Second, it's not being violated by any other agency or individual as well. So if there is, then they will be protecting and they will be creating those mechanisms through which the protection can be sought, even if they have to, meaning by we can say including a clause into Indian Constitution for the remedy. Then again they can have the commissions, they can have the independent courts, where of course the any remedy can be sought. So all this will be efforts made by the state. Now duty to fulfill, once again they are saying that protection and all these things, which is the very much part of the state system, they have to actually ensure that they do all in perfect manner without we can say jeopardizing or harming the interest of the individual or any other such body. Now they're saying that they have to provide a duty to provide remedy at the domestic level that I just shared with you. That either mechanism they can create. You might have heard about National Human Rights Commission. You might have heard about the State Human Rights Commission. You might have heard, of course, courts structure. You might have heard about the writ system that is applicable in high courts and Supreme Court when the violations are happening. And of course, there will be some tribunals also, some commission, other type of commissions will also be there, like Minority Commission, you might have heard. So these are the things that and of course, Women Commission, you have heard, Child Commission, you might have heard. So all these things have been expected from the state to create for the purpose of the proper implementation of these rights that are there. Now we are going to see the scheme of rights which are present in the this covenant of Iccpr. They are saying that once again we are going to look, the scheme goes like that. First is the preamble. Second is the general that they are talking about, Article 1 to 3 and 5. Rights in emergency, they are having Article 4 because they might be taking the status of the state also into consideration. You remember I just made a mention that there will be certain rights that can be suspended during the emergency. So we will be discussing about this aspect as well. Again, they are saying that there is a group called substantive rights that is going from Article 6 to 27. So we can say major share they are taking. Implementation of enforcement machinery. Then once again, Article 28 to 45, they are speaking in terms of that. Then again, we are going to see that how they will be making a kind of instrument and mechanism, how we can available them. Interpretation of saving provision, Article 46 to 47. Final or concluding provisions regarding ratification of accession of covenant amendment. As you know, it is all some particular regular important part of an international agreement. So there is no need for us to focus on that. But then, yes, certain aspect I might be speaking in terms, because we know when we are talking about that what the ratification and all these accession do mean for us. Then again, the preamble, what the preamble is saying. Some important part I have taken, not the whole preamble. Some thing that I thought must be known to you. If you see that this is saying the almost same thing they have taken from UDHR. They are saying, considering that in accordance with the principle proclaimed in the Charter of the United Nations, recognition of inherent dignity and of the equal and inalienable right of all the members, the human family is the foundation of freedom, justice, and peace in the world. Here they are going to bring, of course, the private domain also into picture, and that will be the family, actual family. Here they are talking about the international family, but they are going to bring the family part also into discussion. Here they are saying the machinery for implementation of Iccpr. That is the one that they will be talking about. Human Rights Committee was established. So this is HRC will be very much there, which is consisted consisted of some 18 members established by Article 28 of the Covenant. Part 4 speaks in functions. So I'm going to discuss certain functions with you, because if somebody wants to approach these bodies, one can see that how things can be done and what they are supposed to do. To monitor and supervise the implementation by state parties of their obligation under the covenant is the very important aspect of it. Again, we are going to see the next aspect that, as I shown you, reporting. Reporting is the must that the state has to submit. Every state, whosoever is the member of this Iccpr, they all have to submit annual report, and this report will be screened by this committee. So they are saying that, of course, they are bringing some issues which will be discussed during a constructive dialogue with the state. This committee will be entering into that after going through the report. On the basis of the report and the replies, the list of issues submitted by the state and civil society, the committee would then prepare its concluding observations, which will be, of course, displayed on the website. So one can see that when the issues were being submitted to them, that what was the outcome of it. Second, they are saying considering individual communication. You remember I told you that optional protocol 1 is about this communication. Second protocol I'm not going to discuss with you. It is about the death penalty thing, which is of course has been passed, and certain states are having reservation. Here I'm focusing more on this, considering individual communication part, which is very much important for ICCPR. They are saying that they will be giving a model complaint form. What they will be expecting, a person might be providing into this basic information, the state party to which the complaint is directed against, and the rights set out in the ICCPR that have been alleged to the violated. Steps taken to exhaust the local remedies, we can say, and we can also call it domestic remedies. We know that generally what is the procedure like. We know that whenever there will be issues regarding the violations of rights, then we are first going to take the recourse to the local courts and local mechanism. Like as I told you, National Human Rights Commission is there, and of course judicial courts are there. So one has to approach these commissions first, and if still one doesn't find any remedy, then of course these forums can be availed. Otherwise, what will happen if somebody goes bypassing the national forums, then and reaches to the international forum, they will send us back to these forums once again. So one has to be very sure that first one has to explore all the local remedial measures. Only then after that, if it is not satisfactory, then one can go to that. Then a chronological list of facts on which the complaint is based, a checklist of the supporting documents, including copies of complaints or decisions before domestic courts, and corroborating evidences. So we know that it is an important component of it, that when we want to do this, these are the mechanisms. Third point, they are saying how it will be done, issuing general comments. After looking at these reports, generally what HRC does, it give observations. I think website, when you go visit the website, you may find a lot of things where the lot of articles have been interpreted, and of course interpretations have been given, and the right position has been given by the this particular human rights committee. Considering interstate complaints, both the state concerned must have declaration accepting this procedure, or complaint will not be considered. Sessions are held 3 times a year, either in Geneva, so or this particular committee meets like that. Now here again, once again, I have created a combination for you, where you can see that once again, that how India has taken these particular ICCPR articles into Indian scheme of Indian Constitution. Once again, when I go to it, I have shared the document with you, so you can spare time and you can have a look at that. For you, I'm just going to read as far as this Article 6, Clause 1 and 9.1 is concerned. You see that the language is almost the same, almost. They say Article 6, Clause 1, every human being has the inherent right to life. This right shall be protected by law. No one shall be arbitrarily deprived of his life. Once again, I'll remind you, or rather I'll just make you aware that they say procedure established by law in India. The right to life cannot be taken away without adopting to procedure established by law. So this is something that has been very much protected by that. Then again, when they speak in terms of Article 9, once again, I'm going to give you the language, what they are saying, because it is once again equivalent to Article 21. They say that Article 9, Clause 1, once again, the language is, everyone has the right to liberty and security of person. No one shall be subjected to arbitrary arrest or detention. No one shall be deprived of his liberty except on such grounds and in accordance with such procedure as are established by law. So you can see that this combination of 2 articles, Article 6, Clause 1 and Article 9, Clause 1 of ICCPR and the language of Article 21 of the Constitution of India is very much complementary. Again, you can see I have given you, the number of combination when you look at that. And here, I think this is a kind of complete combination that I'm sharing with you here. So you can have a look at that, and when and the language, when you match it, you can just find, the same thing is existing here as far as these things are concerned. Elaborate scheme of Article 21 already I gave you. I think number of things when I gave you in the UDHR, I have created that particular you can say chart or table, whatever, or rather you can say that particular order that I have given you. When you go through all this, because we know that what have been the fundamental scheme as far as these things were concerned, freedom they talk in terms, life they talk in terms, and of course, when they talk in terms of freedom, freedom they classify into different categories, as we know about the speech and expression, and they say opinion and expression. Then once again, we can see that they are talking prevention from the arbitrary arrest and detention. Once again, we can see that they are talking about the freedom, to have freedom of faith, and of the people can, of course, propagate their own religions and all that kind of thing. They are talking about equality clause. They are talking about, and they are having similar thing as they are having in. If you see the Iccpr Article 14 Clause 1 is the same as Article 14 of the Indian Constitution, where they are talking in terms of equality before law. I can just once again give you the language of Article 14 that is speaking in terms of the equality part as far as the Iccpr is concerned. It says that the clause 1 of this says that all persons shall be equal before the courts and tribunals. As you just recollect the language, those who have seen the Indian Constitution and Article 14, in the determination of any criminal charges against him or of his rights and obligations in a suit at law, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. The press and the public may be excluded from all or part of a trial for reasons of morals, public order, or national security in a democratic country, or when the interest of the private lives of the parties so requires, uh, or to the extent strictly necessary in the opinion of the court, in special circumstances where publicity would prejudice the interest of justice, or any judgment rendered in a criminal case or in a suit at law shall be made public except when the interest of juvenile persons otherwise requires or proceeding concern matrimonial disputes or the guardianship of the children. So they are, that you can see the language sounds very familiar, as we are having in the, our own constitution. So this is something we can say that all these covenants and these things are very much, present in our own constitution, and we are enjoying those rights under that. Now the question arises, there is one more issue that we talk in terms of that. And when we are, speaking in terms that we have heard that rights are not absolute. So they are also speaking in terms of human rights. They are saying that there are certain limitations. There are certain, we can say reservations, and there are certain, we can say, as far as the derogation part is concerned, these three steps are also important for the implementation of these rights. First, we have identified that what are these rights which are, mentioned in these covenants and in UDHR, and I have shown you that how they are very much a part of the Indian Constitution. Now we are going to see the scheme of implementation. We have seen the forums will be there, but then once again they are saying, but can these rights be limited? Yes, of course, limitations can be imposed, because even international law, as I just explained to you, that state has all the autonomy to, choose whatever it wants to convert into right, whatever it doesn't want to convert into right, and whatever it wants to suspend for the time being. And then again, the international scenario is imposing certain kind of, restrictions on this power also. When they say, because if you remember, I gave you Article 4 of this Iccpr, which speaking in terms of emergency. Now I'll just, give you that what are they saying as far as the emergency part is concerned, because when we read fundamental rights in Indian Constitution, we are very much familiar with this clause, because it is being treated as an exception, to these particular situation for the enjoyment and implementation of rights. Now, what do they say in the Article 4 of Iccpr? They say that in time of public emergency, which threatens the lives of the nation and the existence of which is officially proclaimed, the state parties to the present covenant may take measures derogating from their obligations under the present covenant to the extent strictly required by exigency of the situation, provided that such measures are not inconsistent with the other obligations under international law and do not involve discrimination solely on the ground of race, color, sex, language, religion, and social origin. So they are saying that yes, of course, this particular thing is allowed. Again, they say in Article 4, no derogation from Article 6, 7, 8 that you can remember. They were talking in terms of life, liberty, and all that, may be made under this provision. Again, they are talking, as they say, that any state party to the present convention availing itself of the right of delegation shall immediately inform the other state parties to the present covenant through the intermediary of the Secretary General of the United Nations of the provision from which it had derogated and of the reason by which it was actuated. A further communication shall be made through the same intermediary or the date which it terminates and derogation. We know that we have a situation on our hand, a kind of crisis which is going on currently is an international crisis, which is a pandemic. We know which is going on, and we know that a lot of international things did also happen. We brought our own citizens from other countries. We also detained nationals of other countries in our country for some kind of violations. So of course, such kind of situation do arise, but then it can happen with the agreement of the other states. So these are, certain steps that when we try to understand about these things, that these things are allowed, meaning a state has been allowed to suspend them, but then there must be a real justification. It is not for the purpose of political expediency, which is very much rejected by the international scenario. So we can see that the thing must be genuine, and if there is a genuine situation, then of course a state can take extreme measures. There are a number of situations, as and when we discuss about it, when the discussion come out, we can also discuss about certain situation, because we know that there are issues when the violations of the rights will be considered by the state as a violation, which is our state might not be doing. Instead, it might be protecting those rights. So we can see that as some rights are concerned, which are left as far as these things are concerned. It is part of another covenant which was in combination. So that I'm not taking, because it is speaking in terms of right to work, health, and all those kind of all these issues that I'm not going to cover in this. So I will be confining myself to only Iccpr. Okay, so that is I can say, because two complementary things I have spoken about. One is UDHR, that particular component of UDHR, which is of course becoming part of Iccpr, and which are becoming part of the Constitution of India, where it becomes a kind of legal we can say mechanism or legal thing that can be implemented, and that can be enforceable in the court of law, meaning we can say it become more effective. Now we can enjoy that, and the violation will be very much subject to the punishment by those who are violating it. So these are some of the points that I wanted to share. I hope things would have been fine with you, or you would be in a position to understand all these things. And now I would like to discuss certain things with you, that if you have any questions, any observations, or any new information to add into this, because we know that right to life and this right to privacy, when it came into the picture, what all has happened, we know that certain cases has come when Section 377 was a point of discussion. We know when the point of a third gender was also brought into the discussion. So all these things we may discuss when we say as far as these issues are concerned. So I would like to hear certain things from you. I think I have spoken enough as far as these two things are concerned. So generally, some whatever is what should I say, as the main scheme of these two covenant or declaration I have given you. So these are the issues. Now I end my thing here. I would like to thank all of you once again. And once again, I say it's an humble effort. So of course, there may be certain things, perhaps, though I have made my level best to cover, but might have left. So let's discuss, open discussion for that. Thank you so much.
Thank you, ma'am, for such an insightful and informative session. The floor is open for questions. The participants are welcome to ask their queries in the chat box, please. Ma'am, we have a question which says that in case of individual communication as per OPICCPR, in the report of committee given to the states just as a suggestion without any legal effect?
Uh, can you repeat the question, please?
In case of individual communication as per
Right.
OPICCPR, is the report of committee given to the states just as a suggestion without any legal effect?
No, it is. See, the thing is, that is what I was just discussing with you. That certain thing I would like to once again, will be throwing a light. We say that ICCPR is an international covenant, and we know the status of international covenant is that nobody can force a state to actually go by that, unless and until a state decides to implement that. But now, once again, they are saying that this is an age and era when the state cannot actually avoid such kind of obligations. They have international obligation to fulfill. So that's why when they submit their reports, okay, they give all the situations because who all are submitting? The states are submitting their reports about, of course, the violations which are being committed not only by the people or the agencies, but the states also. So they are generally speaking and submitting the reports for each other. As far as the individual is concerned, they have been given open forum that they can also approach HRC by adopting all these measures that I told you. As far as reporting is concerned, what state might be reporting, you can understand, because they might not be reporting the things that might be actually, undermining or underestimating their situation. So a person, if is having any particular grievance which has not been addressed by the state as per the law of the country, because once again they are saying that the grievance should not be of a nature that which is not supported by any law of the country, because no international agency can interfere in the internal affairs of the state, which is what do they mean by that, that they are talking about the laws, because the state will be governed by a law, a legal system. So if they are speaking in terms that if unless and until there is a blatant violation of the law, while giving or addressing to the grievance of this person, this cannot be actually taken to the international forum. But if it has happened, if abuse has happened, law has not been implemented properly, the law has not been applied properly, then of course an individual can go to those forums. As I told you that they have given a model format, and these format can be filled by that, and the grounds also I gave you, that what all has to be provided for that particular kind of individual complaint, because this covenant, optional covenant, is dealing with that only, that how it must be done.
Thank you, ma'am. Ma'am, we have one more question. In case of emergency, are there any basic standards that the state have to abide in order to ensure the individual rights are not violated?
Yeah. See, you remember that I think we have certain things like when we were talking about when rights can be suspended and what right cannot be suspended. We know about that. You know that India has created a mechanism of Article 32 and 226. Especially, I will focus on 32, because they are taking it as a particular kind of very strong measure. Meaning, we are saying that right to life cannot be taken away without any justification. But liberty can be taken. If there is an emergency, if there is a situation, then they can take. Okay. But then, as I told you, that this is something one has to actually prove that this was not genuine. This was something that has been actually for the sake of political expediency. Like we know 1975 was a year. We knew that what has happened in the country, that there was an emergency formally declared, and then of course people were thrown in jail. And who were the people who were thrown in jail? Who were the opponent of that? Whosoever was speaking against was thrown into jail without any, adopting to formal measures. So this was something has been treated as an abuse by the state. So they are saying, because what is happening, why we are saying abuse? Because what was denied at that point of time? That these people were not in a position to approach court. Because MISA, you might have heard, that they have imposed that particular thing, and people even cannot approach the court. Because this was the situation. So they are saying that if such situation exists, when a person who has been subject to such kind of ill treatment due to the emergency is denied to go to court, will be of course something that will be equivalent to the abuse. But when they say, because they are using a language that I gave you as an emergency, when they are saying that there is a national threat, our security is jeopardized, and of course the real situation is on hand, then they will of course deny. Like I gave you example, you take example of Corona. What did they do? They imposed a lockdown. Now this lockdown did what? It asked us to stay in our home. Now can we defy it? It was not a law, or was it a law? It was a kind of thing that was declared by the state to remain inside your house. Why? Because it was life-threatening. And since it was directly affecting the life, people decided to stay in that. So nobody can, and of course, law was there. If somebody tried to defy this particular thing, then they will be punished by the state. Now, can one seek remedy against it? Because we knew that there was a genuine situation. There was a genuine situation because we knew that people are actually getting sick. Now you can see what is happening all around us. When central government has relaxed its control, the numbers are increasing. So there was a real situation. So we have to actually understand the real situation or a particular, made up situation. If somebody is generally for the sake of self-survival, some leader, some political party, for the sake of self-survival, trying to impose an emergency, which is not an emergency. Emergency, if you see, Indian Constitution is also defining what will be treated as an emergency situation. Unless and until that situation passed that test of Constitution, because we know every measure, every step that is to be taken by the state government has to be within the limits of the constitutional provisions. It cannot go beyond that. Now, what we have done, we have made these two, covenants and declaration part of Indian Constitution, which is the supreme law of the land. So we are fulfilling those particular things by the Constitution. So Constitution in itself is very clear about the emergency also, that when there is a constitutional machinery is broken, when there is a financial one. Now we have seen this particular disease one, that the health was jeopardized. Health means the life was jeopardized. So we have actually seen a genuine emergency situation on our hand, and of course the things were dealt with in that particular manner. So these are the things that nothing can go beyond the scrutiny of the law, and of course the limits set by the law. Every single action of the state has to be in the line of law. If there is something which is not clear, one has to go to the judiciary for interpretation either, or if something which is part of the Iccpr or UDHR, they have to go to HRC internationally. They have to seek an explanation of particular provision that in such situation, how the situation must be interpreted. When you go to the site, you will see that they have made these general comments. There is a category that they have said that after receiving any particular query or particular, these reports, if a state wants to clarify on a particular issue, they will be giving general comments, and the state has to go through those general comments. And of course, once again, as we say that no state can afford to breach rule of law itself, because everyone is governed by rule of law. So is it clear?
Yes, ma'am. I hope the person who has asked the question might have got the answer.
Meaning the emergency also. Emergency cannot be just like that. It has to be very much within the ambit of law.
Yes, ma'am. We have one more question. Ma'am, in case of any human rights violation in a nation, can Iccpr intervene?
Vita, you have to come again. Your voice is breaking.
Ma'am, the question is, is in human rights violation in a nation, can Iccpr intervene in the...
Bacha, voice is not clear. Can you write in the message box?
Sure, ma'am.
So I can see that. No, they cannot. As far as any international agency is concerned, they cannot, because international law is very particular about this thing, that a state is a sovereign state, and sovereignty cannot be breached by any other actor. Whatever is happening, unless and until situation is we can say the displacement is happening, there is a spillover effect, meaning other state is also getting affected and the state is requesting for intervention. Only then it can happen. Otherwise, they cannot intervene. Because otherwise, what will happen that then this whole idea of international law that we are trying to understand to create an order will be getting converted into disorder. Once again, the this power game will start. Many a time we hear, of course, the most powerful state of the world, which has created doctrine of its own. You have seen they have preemptive strikes and all that, where they have said that if their nations are threatened in any country, they have got a right to attack it. We do not know from which international law they have got this particular idea. But then they many a time do implement it. But then you see the reactions. People don't give positive reaction because there are mechanisms like there are Security Council, there is General Assembly, which are supposed to actually discuss all these things. But on their own, they cannot intervene without the consent and approval of the state, unless the situation is so volatile that it has actually become very impossible. They cannot intervene. No agency can intervene for that matter.
Thank you, ma'am. Ma'am, we have one more question. Am I audible now?
Now you're audible.
Ma'am, the question is, what is the role of NGOs like human rights and the civil liberties groups in the treaty compliance process?
Yeah, see, ECOSOC is there. We know that this economic and social rights and all of this charter is there, which is very much responsible for the implementation of all these things. Yes, of course, civil society groups are very much allowed, and of course, they are also not only allowed, they are proving to be quite a great pillar of strength as far as the states working in these areas are concerned. But then once again, that like a state, they should also not found wanting on certain grounds. Whatever is the mandate must not be actually proving detrimental to the interest of the people and the state itself. Because if you remember, I'll take you to Indian Constitution now. If you remember these Article 19(1)(a) to we can say G, you just see in the first 1(a), what do they say? There are certain conditions where they are saying that if state feels, because reasonable restriction term they have used, they say that whosoever, it could be anybody, even a civil society group, if they are actually, they also have to work within the limits of the law, and they are very much allowed, and of course they also get recognition and appreciation. It is not that they are not, and of course, as I say, they are a great partner in the implementation and good governance that is to be performed by a state. But then again, they too cannot cross the limit of law, and if they, then of course there will be issues that they cannot do so, because they have to be they have to submit certain records, they have to, as I say, the law of the country they have to follow. If they are not following, then of course the state government has got all the right to stop their functioning, or can of course question them. So state is the supreme one. The state is sovereign, and the state, above state only is the law through which the state is being governed. When I say state, I am referring to the government part, because the state in itself is the highest authority.
Thank you, ma'am. Ma'am, we have one more question. Can a citizen of India bring the claim against China for infringing his human rights because of the gross negligence and acting without due diligence on behalf of China?
In the current situation that they are talking about, once again, see, I'll just tell you within one thing is there. Whenever such issues are concerned, these two states, meaning when you say international, these two states first will get into contact with each other, because directly they cannot, as they said, that first you have to exhaust local remedies. So whenever there will be an issue, if an Indian has grievance, then it has to, of course, file the complaint either in its own court, or it has to, of course, approach the Indian government to bring its claim against the government of China on behalf of its individual, because the state is the one responsible for the protection of individuals' right. So on behalf of this individual, the state can propose its case in that. Or of course, if there are mechanisms available in any agreement through which this person wants to do that, they can directly approach the foreign court if the agreement says so, because the whole international happening is based on the terms and conditions of the agreement. So if they have such arrangements, people to people contact and all those kind of situations, then of course they can approach them, and if the grievance is there, they can file a case against them. So this can be done. But then again, there are issues. It's not, he is not or she will not be stopped And it depends upon the nature of the case, that what it is, what is the issue involved. Like if we talk in terms of corona thing, that the whole world is behind China. So that's why we can understand that first local remedies has to be exhausted as far as these issues are concerned. Nothing can be taken directly to the international forum. It will not be through proper channel.
Thank you, ma'am. Ma'am, there's one more question. Here the participant says, ma'am, I think there's a significant distinction between the powers and the authority. The international laws may have the authority to prohibit certain abusive and derogatory actions, but do they have any power to ensure the implementation?
See, because the thing is, as I say, that grievance is of what nature? Meaning, what is the grievance? It depends on that. If there is a human right violation, if when we talk in terms of that right, liberty, and all those kind of things have been done. Like, suppose if we take example, if somebody is being arbitrarily arrested by some state, then we have seen Jada's case, that India has gone to the international forum. But prior to that, you see that how many times India has tried through its consulate to speak to China, to Pakistani government. They tried, and you have seen that they have got this access to council saying that they followed all the steps. So these are the things that they can do it like this. Through diplomatic channels, they might be moving the things. Okay, the first the grievances of the citizens will be taken up by the state. In another state where the consulate is established, and of course they might be voicing the grievance of that particular individual. So yes, of course it can be done. It is not that it cannot be. So we know that when these envoys, ambassadors, these are supposed to represent our interest in the other country. So if our citizens have any kind of, and you might have seen that even in the Middle East and in these Gulf countries where these people have faced difficulties, the Indian government has tried to resolve those things with the, of course, negotiation with these states. The thing is that diplomatic channels have to be exhausted. The diplomatic negotiation will happen, and of course, the remedies will come. Definitely will come.
Thank you, ma'am. Participants, are there any more questions or queries? Okay. Thank you, ma'am. Thank you, everyone, once again. And especially thank you, ma'am, for sparing your time from your busy schedule. Now we can end this meeting, and thank you, everyone, for joining. Hope you had a great session.
Thank you, Beta. Pleasure is mine. Thank you once again.
Thank you, ma'am.